5, 4, 3, 2, 1. In this petition filed under the provisions of Section 482 CRPC, the legality of an order by the Metropolitan Magistrate, New Delhi, on 25th April 1989 on the application moved by the Customs Department under Section 110(1)(a) of the Customs Act 1962 is assailed on the plea that the order suffers from inherent defect as it has been passed without any notice to the petitioner, whose rights were likely to be prejudicially affected, and without affording him an opportunity of being heard. The facts, insofar as they have a bearing on the point in issue here, are that, as per allegations made in the application moved on 20th April 1989 by the Special Public Prosecutor for Customs Department before Metropolitan Magistrate, New Delhi, who is link magistrate to the Additional Chief Metropolitan Magistrate, New Delhi, contraband goods consisting of VCPs, color film rolls, photopapers, etc., all of foreign origin, were seized from different places on 18th November 1988. The seizure was effected in exercise of the powers under Section 110 of the Customs Act 1962. These inter alia included 676 VCRs, 357 VCPs, and 59,900 color film rolls and 4 photopapers, all valued at rupees 1 crore 66 lakh 80,000, recovered from 201 Sainik Farm, New Delhi, which premises were under the control and possession of Parasram, the petitioner herein, pleading that these goods required immediate disposal, and further that if these were not disposed of, the same would be destroyed and thus result in national wastage, and that it was in the interest of justice that the case property, namely the goods which were notified for the purpose of Section 110 1A of the Customs Act, are sold or disposed of. The magistrate was approached with the request to certify the correctness of the inventory, taking photographs and certifying such photographs as true, allowing to draw representative samples of the goods, and certifying the correctness of the list of samples so drawn. The application concluded with the prayer that appropriate orders as required by Section 110(1)(a) and 110(1)(b of the Customs Act be passed. This application was disposed of by the concerned magistrate, wide order dated 25th April 1988. After hearing, he, appearing for the Customs Department, who had moved the application, after reproducing the contents of the application in respect of the description as well as quantity of the goods, and taking note of the scheduled items as notification issued an exercise of the powers conferred by Section 110(1)(a) of the Customs Act, he allowed the application and directed that an inventory be prepared in respect to 676 VCRs, 357 VCPs, and photographs could also be taken, as also their representative samples, and thereby disposed of the application. Mr. H. Singh, appearing for the petitioner, raised a basic issue in respect to the impugned order, contending that on all counts the property was arrested as a sequel to the recovery of these goods, and he is being remanded to judicial custody on the applications made by the Customs Department, and was liable to face prosecution under Section 135 of the Customs Act, and further that the adjudication proceedings with respect to the same seizure have already commenced inasmuch as the petitioner has been served with a so cause notice, and further that on same facts he was placed under detention in exercise of powers under section 3(1) of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, and was confined to Central Jail, Tihar, at the time the present petition was filed. He contended that the implications of this order were very far reaching, and that the direction for preparing of inventory or other matters covered by the order are steps towards disposal of this property under the provisions of section 110(1)(a) of the Customs Act, and that once it is done there shall be no case property left, and the petitioner's defense during trial as well as adjudication proceedings would be very seriously affected, and that it was the requirement of fair trial and natural justice that the application ought to have been disposed of by the Metropolitan Magistrate after notice to the petitioner and after hearing him. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.